The next round of stimulus includes a provision for the business liability protection. And what business liability protection is a rule that would broadly shield businesses from liability should somebody file a claim saying that they contracted COVID-19 while on the premises or engaged in business with that particular establishment. So that way, a business can hire employees back without being afraid that they're going to be subject to a lawsuit. Advocates of the liability protection say that if you're a small business and somebody accuses you of maintaining an environment where catching coronavirus is likely, that the amount of time, energy, and money it takes to fight off this kind of lawsuit, even if you win, is enough to bankrupt already struggling businesses.
Businesses have found that they can ask for waivers, but in many of the states, waivers are considered unenforceable. There's also a concern from an interstate commerce perspective that by having various standards, it creates confusion for businesses and thereby increases their cost and therefore a desire to have a uniform standard. Generally speaking, this proposal is tantamount to providing absolute immunity for businesses.
Detractors of liability legislation say that the widespread immunity from lawsuits would unfairly place the burden of proof on an employee or customer to show that they contracted the virus at a particular business or workplace. That's kind of a difficult task to do. It's very hard to prove where you actually came down with coronavirus or even the common cold.
The standards in the proposal, in particular, if someone were to bring a claim, someone will have to enumerate when they believe they may have gotten COVID-19 and do a form of contact tracing before they can even bring a claim. The bill changes the standard from a preponderance of the evidence to clear and convincing evidence. That significantly raises the bar in a negligence claim. It notes that a lawyer can be held legally responsible, as well as their law firm, for writing a demand letter that is later determined or characterized as frivolous because it did not meet these recent and higher standards established in this bill. This bill is about reopening, yes, but reducing costs of operations for businesses.
Senate Majority Leader Mitch McConnell and Senator John Cornyn have proposed these rules to broadly shield businesses who make what they call a good faith effort to protect their employees from contracting the virus. As written, the proposed standard would extend all the way through 2024, and it would also apply retroactively to when the coronavirus first began to circulate in December of 2019.
Employees may not have as much flexibility to not return to the workforce or their jobs, and those employers may not be as conscientious, if you will, because the liability rules give them almost absolute immunity.
Liability protection is a red line in particular for Senator McConnell. He is up for re-election in November, and he's repeatedly stated that the issue of liability protection is paramount to legislation moving forward.